Assalamu alaikum, everyone. Good morning. Thank you for joining us today on the second session of AlNukhba Program. We are happy to continue the journey and move on to another critical topic for companies that are preparing to come to the capital market. We'll be discussing today legal and compliance. The session will be delivered by Eversheds, who are one of the leading international law firms operating in Qatar and globally. We have today with us Mr. Sarkis, who is a leading, who brings great experience of 18 years to the firm. He is based in Doha, and he advises on IPOs, listings, mergers and acquisitions, corporate restructuring, and joint ventures. He played a key role in many landmark transactions on the Qatar Stock Exchange, including the IPOs of Miza and Baladna, and the listings of Al-Mahar and TechnoQ. Mr. Samer is also ranked in the Chamber Global and Legal 500 for his leadership in corporate and capital markets, and he is a member of the Beirut Bar Association. We also have with us today Ms. Marwah Rawashdeh. Marwah has worked closely on listings and M&A deals and is currently based in Doha. She has advised on the listings of Miza, Al-Mahar, and Bima on the Qatar Stock Exchange. Prior to that, Marwah worked in Eversheds' Iraq office, supporting clients, specifically in the energy and construction sector. Before we begin, just a quick reminder, all microphones are muted, so if you have any questions, please use the Q&A segment, or I can unmute you in the end of the meeting. Thank you so much, Mr. Samer, Ms. Marwah. The floor is all yours.
Thank you, Sulaiman, and thank you for the audience. I will make Sulaiman has kindly provided a brief background on my experience. I'm Samer Sarkis. I'm leading the capital market team in Eversheds, Sutherland in Doha and the region. I have been in Doha for more than 18 years. As Sulaiman highlighted, I have worked on most of the capital market transaction in the past 6 years. From Baladna to recently Miza, TechnoQ, Qatar Electronics, Al-Mahar, Al-Faleh, and we have of course assisted on several other M&A transaction and public companies. We have as well assisted on several drafting of laws and assisted the state of Qatar in relation to the World Bank. And I would be pleased to present to you today a brief overview on going public, things that entrepreneur should know in relation to the conversion of the company from a private to public, and what does it mean to become a public entity. I will leave the floor to Marwah to introduce herself, and then we can proceed forward with the schedule for today.
Thank you, Samer. As Sulaiman has already introduced, good morning, everyone. My name is Marwah Rawashdeh. I'm part of the commercial and corporate team at Eversheds Sutherland in Doha. I work closely with Mr. Samer Sarkis, and I primarily focus on corporate and capital markets matters, as well as a range of commercial transaction, regulatory matters and business operations. It's great to be here today. Hopefully we will be able to deliver an informative session for everyone today. So first, just as an introduction, today we're hopefully, if the time allows us, we're aiming to cover a variety of topics. First of all, we're going to briefly touch upon going public in Qatar. What does it mean to companies? We're going to also kind of provide an explanation as to the differentiation between main market, venture market, whether you're going to list through a direct listing or an IPO. We're also going to touch upon who regulates the process, and generally explain the legal journey to going public. After that, we're gonna go into kind of the different compliance obligations that the company needs to consider moving forward after it becomes a public entity. This includes disclosure obligations, business ethics, conflicts of interest, and other matters such as protection of company assets and insider trading. So Samer, would you like to give us an introduction here?
So going public in Qatar, what does it mean? It's very important to highlight that most of the companies in Qatar, family businesses, they sometimes consider moving and becoming a public entity for several reasons. Why we need to go public? What are the benefits of becoming public? And what does it mean legally? Becoming public in the different regime that we have in Qatar. As you know, we have companies established in the Ministry of Commerce and Industry, companies established in the Qatar Financial Center, companies established in the Qatar Free Zone Authority, the QSTP. So there are several companies that could go public in different way and depending on each regulation. I will give a simple example. A company established in the Ministry of Commerce and Industry could be a limited liability company and could be converted into a public shareholding company, or a private shareholding company could be converted into a public shareholding company. And as well, sometimes we do a general restructuring for the group of entities and create a newly owned company that will become directly a public entity. There are several way to go in public from legal perspective. Similarly, if we talk about Qatar Financial Center, for example, it's a limited liability company that would change its form to become a limited liability company addressed to public. Similarly, in the QSTP, the way is to convert in a limited liability company into public. The legal framework of converting an entity into public is of course contemplated under all the laws of these jurisdiction based in Qatar, and of course all these are doable for the purpose of the conversion. But there is something very important that we need to be aware of by going into public, which is the main point is what's the difference between a private entity and a public entity. When we move to a public entity, this means more compliance, more transparency, more reliance on the status of the company as a public entity, more comfort to third parties dealing with this particular entity, in particular financier, banks, third-party suppliers or third-party clients, because the entity becomes into its framework as an entity in the public. Everything is disclosed to public, and then the entity would become public, and all the transactions, major transactions, are known. So it's very easy in a like a transaction or in a particular matter to be able to find all information related to this entity. And this is something that would provide comfort to the third parties dealing with the company, and as well for the entrepreneur, that their entity is now an entity that follows corporate governance, follows the best practice of an entity, and then follow something very important, which is the succession planning for this entity. This entity can move from people to people, from generation to generation, on a very strong basis, because this entity is not relying on an individual or a person, but it's relying on the governance that it has, the governance that the directors are following, the governance that this company is following. That's in general. What does it mean moving from a private entity to public entity, the major difference is the governance of this entity, is that this entity information are transparent and are being disclosed to the shareholders and to non-shareholders as well, which provide a certain comfort to the shareholders of the company and as well to third party dealing with this particular entity.
And I think, as Samer just discussed, there are different kind of implications as to going public and different responsibilities and introduced responsibilities. So I think it's very important to kind of for the company to really understand the options it has before it decides to make that very important step. So in Qatar, companies have several pathways to access the capital markets at the Qatar Stock Exchange. So each of those pathways are designed to suit different types and stages of businesses. So just to briefly go over the main options, as you can see on the slide now, first we have the main market. So the main market is the traditional platform for larger, more established companies with a proven track record, solid financials, a broader operational footprint, I would say. But it's really important to kind of consider that the listing requirements here under the main market are, they tend to be more stringent, especially around profitability and basically capital requirements. Whereas if you look at the second market, which is the venture market, it's normally tailored for small and medium-sized enterprises and high-growth companies that may not meet all the main market criteria. And normally it's viewed to kind of offer a more flexible regulatory environment while still providing those companies to access to capital and visibility. So I think a large portion of the differentiating factor here is kind of the regulatory burden. And I think, I don't know, Samer, if you would like to kind of elaborate on the regulatory side of things and the differences.
So if we go to the technical differentiation between main market and venture market. So if you go to a main market and to list on the main market, there are certain criteria in particular that if you would like, for example, to do a direct listing on the main market, you will need to sell on a private placement basis before going into listing 25% of the shares to to shareholders that are not within the direct family members, include for in particular wives and children less than 18 years old, and then the sale will need to occur before going into listing for more than 100 shareholders. So the entity will need to fulfill this requirement before going public. The entity will need to have a share capital of at least 40 million Qatari riyal. And in addition to that, the shareholders, the founders actually, the founding shareholders will be locked fully on the remaining of their shares that were not sold during the private placement for a year, whereby the founders will not be entitled to sell directly on the market, but actually they will be entitled to do so in the second year onward on the basis that these founders will remain holding at least collectively with the major shareholders 40% of the shares of this entity. Versus the venture market, this would be much more easy in terms of going into the venture market, and this is structured mainly in Qatar and in all other markets for family businesses in terms of simplifying things to go on the market with a less requirement. And as well, I will go back to the corporate governance difference, because there is a big difference from Qatar law perspective and as well internationally, how we differentiate the corporate governance in this market and the other. But on the venture market, for example, in order to go for a direct listing on the venture market, you will need to sell at least in a private placement 10% of the shares to non-founders, and then these for more than 20 shareholders that are non-founders pre-listing, which means in a venture market and the main market, the difference would be that the venture market, the founders are entitled during the first year to sell directly on the market up to 40% of their shares. If we remove the 10% that will be sold in a private placement, this means that the founders will have 30% of their shares that will be free traded on the market for the first year, which provide a certain flexibility to entities that are being listed on the venture market to have the benefit of trading directly on the share of their shares on the market, which is not permitted for entities being listed on the main market. Now, if we move to the corporate governance and governance requirement, of course, we will go through that as well in detail in the session. But there is something very important from OECD perspective, like internationally recognized. And a main market, the corporate governance is structured on the basis of mandatory compliance, i.e., on the main market, you are obliged to comply with the corporate governance code, rather than if you don't comply, you would be able to explain. As per the OECD, which regulates the markets and all policies relating to these markets, a main market entity must comply with the corporate governance code, where this in a venture market there is the concept that is called comply or explain. This means that if you couldn't comply with any corporate governance rules under the corporate governance for venture market, you will be able, or entrepreneur or shareholders or founders or board of directors will be able to explain why they haven't complied and what are the actions that they could be taken to comply. And this would be, of course, listed in the corporate governance code of this entity. So this is the main difference, and this would provide a certain flexibility to entrepreneur to go to the venture market, learn, educate themselves while they are on the market, while they have the same access to their shares to being traded on the market, but in the same time, the management, the founders, the board of directors will learn during the period that they are on the venture market, and it would be easy at a later stage to move from a venture market to a main market on the assumption that you have one corporate governance report presented, and this means that after a year from being listed on the venture market, you will be able to submit your application to move to the main market. But the general idea in terms of difference between main market and venture market, it's not only like the matter that a company is large. There are certain companies that are large but could go on the venture market, but these companies, for example, could be they made a successful immediate growth. We would recommend these people to go on venture market, for example, rather than main market, in order to stabilize their profitability and to make sure they are on the correct track in terms of corporate governance, and then to move on the main market. So these are main technical difference between main market and venture market. But of course, we will be able to answer any question at a later stage when we move forward to the question session. If we move to, yeah, go ahead, Marwah.
No, go ahead. I was just giving you the floor to
yeah. So there is as well a certain differentiation between the mechanism of going into public. So what we know is the initial public offering, الطرح العام الأولي, or direct listing, الإدراج المباشر, which is a mechanism that is adopted in most of the international markets, which gladly we have it in Qatar as well, whereby it allows company to be able to adopt either mechanism in terms of becoming public. The initial public offering can be in two ways. Either I raise capital of the company, and I will make this raise in capital or those shares offer to public in order to inject and then in order to participate in buying these shares in a public offer, which normally the initial public offering occurs, of course, before for an entity that has not yet been listed, but actually before listing. So the entity will offer new shares to potential new investors to participate in this process and to collect additional capital that it's required for certain projection that will be normally mentioned into the plans and prospectus, which which will highlight the reason and how these proceeds will be used, the proceeds of the initial public offering. There is another way as well. It's called initial public offering. However, it is made by way of sell down. An example of these are the two different examples. For example, in Baladna, which is an entity that has been offered, it was an IPO by way of increase of capital, whereby shares were offered to third parties, while in MISA, the recent IPO that occurred, it was by way of sell down, where existing shareholders sell their own shares but into an IPO process, and then it will allow new shareholders, a new investor to become shareholders into this entity. Normally, in an IPO, the price is set, is a fixed price set by the regulator prior to issuing the IPO, and therefore you will have a fixed price, either by way of adopting two valuation, which the QFMA will want to accept, or which is something that we have adopted recently, which is the book building that has been adopted in MISA IPO, whereby seven shareholders, seven strategic shareholders have proposed a price which has been accepted by the founder, and then based on that, the price has been adopted as the IPO price. And these strategic shareholders are mainly financial institutions or quasi or governmental entities that were able to set the price. And then therefore, after the first book building session, the offer will be made to the public on the basis of the price that has been adopted as part of the book building. Now, in terms of in terms of the process of the IPO, of course, the process could be it could take more time than a direct listing. It could take as well, of course, it would take more. The cost of the IPO is much more higher than a direct listing because there are other aspects that we need to consider in terms of advisors, in terms of receiving banks that will assist in this process, which is not there into the direct listing because the sale will happen directly on the market. And then as well the time that is required for an IPO. While in a direct listing, which is al-idraj al-mubashar, whereby as we explained before, the shareholder will have a small portion of their shares, 25% if they go into the main market, or 10% if they go to the venture market, to be sold privately to the shareholders that they decide they would like to sell in a way that when they meet this requirement, they will be able to list their shares directly on the market without the need to lead receiving banks, without the need to go through an IPO process, but directly it will be a conversion of their entity from the status that they are in, a limited liability company, into a public shareholding company, or a normal limited liability company in QFC to a limited liability company / between bracket public, and similarly in the QSTP. And this would allow the entity to be listed, and then shares will be sold directly on the market, and then all the the transfer will happen through the brokerage company and will happen through IDA on the market. Of course, there will be no underwriters, there will be no book runner, there will be no third party to get involved into the sale of these shares, because these shares will be sold on the market, and of course the cost will be much more lower than an IPO. So these are the main difference between the two markets, and of course we will be happy to answer any question at a later stage. In nutshell, who regulates the process? As discussed initially, this will start from where the company is regulated. I just want to highlight something as well. We are talking here about Ministry of Commerce and Industry, QFC and QSTP. These are jurisdictions that in Qatar, but there is something that I need to highlight, that also companies established outside of Qatar, as per Article 5 and 6 of the listing rules, they are allowed as well to list in Qatar to the extent that these foreign entities meet the requirement of the Corporate Governance Code and the QFMA requirement and the QSE and IDA. So it's not only entities that are established in Qatar or the jurisdiction in Qatar that will be able to list in Qatar. There could be foreign entities that they meet the requirement of the market in Qatar that will be able to do their sole listing here, or there as well, there could be certain entities that could be listed somewhere in Saudi, for example, and have a dual listing in Qatar. All these options that could be done as well. But to focus on the companies established in Qatar. So as we said, the regulator of these entities are mainly the Ministry of Commerce and Industry for entities established before the Ministry of Commerce and Industry. The QFC, the Qatar Financial Center, for entities that are established before the Qatar Financial Center. And then the QSTP for the entities established before the Qatar Science Technology Park in Qatar. Now, this is the regulated entities, the bodies that regulate these entities. However, in the process, when we become public, there are other regulators that they have a heavy lifting in terms of the process, being the Qatar Stock Exchange, the Qatar Financial Market Authority, and as well IDA. For entities that are banks, financial institutions that are regulated by the Qatar Central Bank, they have additional regulatory authority, which of course we will need their approval in terms of this process. Now, what the Qatar financial market have included recently in 2022 and 2023 is the creation of the single window committee, which is formed by the Qatar financial market, which would streamline, of course, the process and facilitate the process, which is a committee that is formed by the Qatar financial market, that is constituted by 5 members of the Qatar financial market, 4 members of the Qatar Stock Exchange, 1 member of the IDA, and 1 member of the Ministry of Commerce and Industry, bringing the total number of the committee to 11. This committee has the role to review the any application for potential listing or IPO and provide the comments to the applicant and approving, of course, this application. And they work as well with the advisor to facilitate the listing of this entity and provide any comments on the application in order for the companies to meet and for potentially listing this entity at a later stage on the market. Normally, I give a normal process. If an entity, we will go, of course, on the requirement later on how advisor will be appointed. But from experience perspective, it depends. Of course, the regulator will have their own views of each file, but an entity could be listed if all the requirements are met in a window of 6 months. A 6 months to a 1 year window is an achievable window. We have been able to list entities, for example, Bima, in less than 8 months. It was on the market. Other entities could take more time. It depends as well, as I said, on the motivation, on the meeting the requirement of the regulators, and as well the like the internal team of the company be ready for the public journey. So this is in terms of the regulators that would regulate this process. We go after that for what would be a listing journey in a nutshell. So the pre-listing planning, whereby an entity could appoint its advisor, or it could appoint its own team to see the feasibility of going public. What are the pros and cons for going public? Of course, this will mean the team, the founders will need to learn more on this opportunity, and whether this would be in line with their future plans for the company. And then, so we start with the pre-listing planning, and then afterwards, of course, something very important to do would be the financial due diligence of the company, to see if the company is financially ready to go into public, and legally ready to go into public. Because as we said, corporate governance is very important. The company in a going public will need to create committee, will need to have a board of director, will need to have a certain policies and procedure to adopt in order for the company to be a public company. Now, after the appointment, of course, of the legal and financial due diligence, there will be red flags or like flag to the founders, where could be certain things that needs to be developed, things that could need to be amended to be able to list the company. After that, it comes the valuation work, whereby, of course, founders are normally focus on this part, because this would provide them the real value of their company and how this company will be valued when it goes to the market. And evaluation advisor is very important and key in this process, because they will of course provide an independent valuation of the entity and the real price that this entity will of course be sold to third parties investors. And then post appointment of the valuator, of course the listing advisor and the legal advisor and all the auditors, evaluator will work all together to prepare what we call the prospectus, and legal advisor will prepare as well the constitutional documents of the company, from the new articles of association, the new memorandum of association of the entity, the charters that will need to be adopted by the board of directors and the committees under the board of directors, in order to be able to submit the application to the single window, which we discussed earlier, in order to review the file and provide their approval. Of course, when the approval is being provided, or the preliminary approval is being provided by the regulator to go public, there will be the role of the marketing team as well to educate the market, or to provide hint to the market in terms that this entity and what this entity does. There are a lot of good companies, but sometimes they are not known very well to the public. And then this is the role of the marketing team to take into consideration, of course, between bracket, taking into consideration all legal restrictions in terms of marketing, and of course taking into consideration what is required by the Qatar financial market when we disclose information about potential entities to be listed or entities that are on the market. And then after that, once the approval are obtained, the entity has been converted into a public shareholding company. The prospectus will be approved by the QFMA and the regulatory authority, being the Ministry of Commerce or the other regulator, depending on the place of the corporation of the entity. And then the prospectus will be published, whether it is for an IPO or for a direct listing. And then after in an IPO, there will be the completion of the subscription period and all these technicalities and formalities completed, which may take more time, as we said, from a direct listing. And then once all these procedures have been completed, the company will be admitted to trading, and then after that, the shares of this entity will be traded on market. And as you know, I believe you are all familiar in terms of trading on the market. There will be no hassle of having an SPA, a transfer of shares agreement, or all of these things. It's not anymore a private entity. It's by clicking the button, you will be able to buy and sell shares through the IDA and the brokerage companies that will be able to facilitate all this type of sale. So that's in nutshell what we have in terms of pre-listing journey up to the listing. And of course, once the journey, you become a listed entity, now it's a new journey that you need to comply with their rules and regulation. There are regulators. There are public knowledge. There are investors that are now with you in the company. A company that used to be owned by 5 or 10 shareholders is now owned by 1,000 and 2,000 shareholders. And we need to have similar treatment to all shareholders, access to information similarly to all shareholders. And then here, where it starts the new journey, which we call it from our perspective, the compliance and the corporate governance journey, which is from the day that the company is being listed. We are a public entity and we need to abide with public entities rule. I will leave it to Marwah now to go through. I believe we still have some time to go through the other section of this presentation.
Thank you, Samer. And as Samer was just saying, transitioning to a publicly listed company does definitely introduce new responsibilities, and it adds a level of visibility. Up to this point of this presentation, we kind of considered the compliance and kind of regulatory issues prior to going public. But the journey actually does not end there at listing. In fact, once the company is listed, there is a heavier regulated environment. There are heightened expectations around transparency, disclosure, and governance. And because of that, in the next section, we'll look at some of the key post-listing obligations, mainly focusing on like financial obligations, financial reporting, different disclosure requirements, different business conduct policies, and all other relevant compliance matters. So to begin, firstly, I think it's really important for us to discuss immediate disclosure obligations. So as Samer mentioned previously, the QFMA, the Qatar Financial Markets Authority, is one of the main regulators regulating a public company. And there are certain disclosure obligations. Some are periodic, some are immediate, that would have to be disclosed to the QFMA. And as we discussed previously as well, the main market kind of has more stringent deadlines, and those reporting obligations kind of have to be more timely and more efficient. So when we're talking about immediate disclosure obligations, immediate in the main market means within 24 hours, and on the venture market, it's around within 48 hours of the company kind of having this kind of event. So here, the thing that needs to be immediately disclosed is significant information. So one would ask, what is considered significant information? So the laws list down a very detailed list of what is considered significant information. So just to give a couple of examples here. So if, for example, the trading was suspended, or the listing of part of the securities in a foreign stock exchange was cancelled, for example. Let's say if a receiver was appointed to the activities and assets of the company, or even the parent company or an affiliate, these are considered significant information that need to be immediately disclosed to the QFMA. Other significant information, such as the sale, purchase, mortgage of more than 5% of the total assets of the company, the parent company, or even an affiliate. From another angle, let's say a lawsuit was kind of brought against the company or any affiliate relating to its board of directors, to its general assemblies. These are all considered significant information, and any company.
And let me add to Marwah here that this is where you can see the difference between a private entity and a public entity. So these things are kind of a normal in a private entity, to see a lawsuit, to see a board member resigning, whereby you need to disclose amendment of an articles of association, for example, appointment of a receiver. All these are called normal acts into a private entity, where we don't need to inform any of the regulators or any of third parties about what about these acts or these actions taken against or by the company. Whereby when we become a public entity, these become important, because this could affect us somehow the price of the shares, and that's why the regulator are strict in terms of providing these information. So it will allow investor, even investor that they are considering to buy new shares, that they are not yet shareholders into the company, to have enough information about this company. And that's why the immediate disclosure obligation are important, either for a venture market or a main market. Like these acts, or what happened in relation to significant information, are nearly similar in terms of acts. However, in terms of the time to disclose these acts to the market, there is certain flexibility, as we have already discussed, in terms of venture market, whereby they have 48 hours, as Marwah said, and 24 hours in main market. And here where we go as well to comply or explain the differentiation, whereby in a main market, if you do not disclose within 24 hours, you will expect a penalty from the regulators, because you failed or you breach an obligation under the law. Where in the venture market, there are certain flexibility to explain why such a disclosure didn't occur on time. And then sometimes the regulator will be more flexible into remedies that could be provided by the company, or action that could rectify any issues or error that occurred by an entity listed on the venture market.
And exactly, and that's why I think a lot of companies sometimes choose to list on the venture market as a first step, and take it as more of a kind of learning stage before transferring into the main market. So because the regulatory kind of landscape is a bit more lenient, it gives some form of leeway, maybe extended kind of deadlines and timelines. So I think, but generally, I think as a publicly listed company, whether on the main market or the venture market, complying with these kind of disclosure obligations are extremely important. At the end of the day, a publicly listed company needs to always show that it's compliant, that it has the effective internal controls, and it needs to kind of showcase some form of transparency and honesty to kind of get that investor confidence and the confidence of the different regulators. And I think it doesn't really stop here in terms of disclosure obligations. Public companies or companies listed on the main market and the venture market, they have periodic disclosure obligations, and these periodic disclosure obligations, sometimes they're annual, sometimes they're semi-annual, or otherwise quarterly, and we'll kind of touch upon those in detail in the next following slides. So just a general overview of the different information that would have to be periodically prepared and disclosed. Number one, it's financial reports. 2, external auditor reports, MLRO reports, and we'll basically explain what this is, corporate governance reports, and finally, business risk assessments. So I think for the purpose of this presentation, we will be focusing on the first 3 points more in detail, and I understand that maybe the last 2 kind of points may have been discussed in previous sessions, so we will just kind of brush over those for the purpose of this session today. So let's start with financial reporting obligations. So obviously, financial information, it's very common knowledge. Public entities need to disclose its financial reports. on a periodic basis. So for companies listed on the main market, it has more obligations, it has more responsibilities. So it would have to disclose annual reports, semi-annual reports, and quarterly reports. Whereas, as you can see on the venture market, it would have to just disclose annual reports and semi-annual reports. And when you really look at the different timelines that you can see on the slide, companies listed on the main market normally have more stringent and tighter timelines to kind of make those necessary financial disclosures, whereas on the venture market, they give companies a bit more leeway to kind of take their time in disclosing such financial information. So I think it's really also important for a company to consider all those different responsibilities and to consider the different kind of admin work and preparation and internal kind of structures that would make sure that it continuously complies with such obligations. And the next kind of information that is also annually disclosed, it's the external auditor reports. So the external auditor reports are normally it's the obligation of the external auditor of the company, and they or he must submit to the QFMA one report attached to the annual financial report, an audited account of the company. Normally, the report must include at a minimum statements covering an assessment of the appropriateness and, let's say, the effectiveness of the company's anti-money laundering and counter-finance terrorism programs, any related policies, procedures, and generally an assessment of how those internal control systems are implemented. Moreover, it would have to also kind of assess the company's ability in continuously engaging and implementing its obligations under related rules. And last but not least, it would also kind of provide an assessment of the company's cooperation with the external auditor. And this also kind of highlights everything and goes hand in hand with everything that we've been discussing previously, is that the constant cooperation with third parties and regulators is very important for a public company to ensure. There is a lot of scrutiny, there is a lot of kind of assessment and different kind of disclosures that need to be made. So I think it's very important for a company to have the appropriate, strong kind of implementable internal structures that allow it to comply with those different obligations. So moving on to another annual reporting obligation, it is the MLRO reports. So the MLRO, it refers to the money laundering reporting officer. So this is an individual that must be employed at management level by the company once it goes public. Normally, this individual would have various duties and responsibilities as outlined in the anti-money laundering and counter-terrorist financing rules. Most importantly, the MLRO would give the QFMA a copy of a report that it prepares annually and which is attached to different annual reports that are submitted to the QFMA. So normally this report would assess the adequacy and effectiveness of the company's policies, procedures, systems, and controls in combating money laundering and terrorism financing. I think it's also important to know that this report would have to be utilized by senior management of the company effectively, and it is normally the responsibility of the senior management to consider each report made to it by the officer. And if the report identifies certain deficiencies in the company's compliance with any laws or rules, the senior management must showcase that it has approved or documented an action plan to remedy any deficiencies identified in the report in a timely way. And I think the responsibilities of the officer, the MLRO officer, are not really constrained around just providing this report to the QFMA. he must also, one of his core kind of responsibilities, that he must also notify the QFMA of any suspicious transaction reports shared with the Qatari Financial Information Unit, which is referred to as the FIU, which is extremely important, and compliance here would thereby kind of showcase the company's commitment and adherence to all applicable laws and regulations. So moving on now, in addition to the periodic disclosures discussed, there is also the corporate governance report that we will not go into details as to the contents of the report. However, it just must be known that this is a report that is normally prepared by the board of directors, and it's signed by the chairman. It is normally standard for it to be prepared on an annual basis or whenever the QFMA is requesting this report. It should also be included in the agenda of the ordinary general assembly of the company, and normally a copy would be distributed to the shareholders during the meeting. In addition to the periodic disclosures discussed, the Commercial Companies Law also kind of sets certain obligations on the company, not only to disclose certain information to the QFMA, but there are also certain obligations to disclose information to its shareholders. So, for example, Article 122 of the Companies Law in specific stipulates that the board of directors normally should disclose to the shareholders a number of different information, basically for their review before any General Assembly meeting. And it's normally shared with shareholders at least 1 week before the General Assembly is scheduled. And this information must be a detailed statement. It must contain all amounts paid to the board of directors, any benefits or bonuses paid to the chairman. If there is any current transaction that the company is undertaking that maybe a board of director, one of the board members or a chairman has a personal interest in. And this kind of touches upon the issue of managing conflict of interest internally. And this is a subject that we will just discuss later on in the next slides. So there is kind of these additional disclosure, not only to regulators, but also internally to your shareholders before General Assembly meetings. And I think finally, so we've discussed what needs to be disclosed to the QFMA, but it's also important to remember that the Qatar Stock Exchange is also a very important regulator here at this stage. So as a general rule, all of the information disclosed to the QFMA should equally be disclosed to the Qatar Stock Exchange. And normally the accuracy, correctness, completeness, and timelines of information provided to the QSE would be the sole responsibility of the company, and would normally, again, as we said, include any information required to be filed and disclosed with the QFMA. If there are any changes to the company's activities or its articles have been amended, if there has been any announcements of general assemblies, in addition to if there is any kind of price-sensitive information related to the company, as well as information to be disclosed by the issuer to the
public. And here to add to Marwah, we normally recommend all listed entities to make the disclosure simultaneously to all the QFMA, QSE, Qatar Stock Exchange, as well as on the website of the company. So shareholders, regulators, and the Qatar Stock Exchange are all in the same time being notified of any of these information or these acts or major events that the company has. So this is always our recommendation, to have this in the same time.
And I think it's very important for to always remember that any information kind of disclosed to the QSE, it may be published on its website, without any review or approval of the content or timing of such disclosures. Therefore, I think it's very extremely important that senior management, before they make such disclosures, to always ensure the accuracy and correctness of all information contained in the report. Just kind of considering the fact that maybe at some point this will be disclosed to the public, and if there has been any kind of factual or material kind of inaccuracies, it would really have a detrimental effect on the reputation or maybe the confidence that the public has with the company. So this is something to also keep in mind, like this general attitude to ensure kind of accuracy and transparency and correctness. Here, I think for the purpose of time, we're not going to go into this slide in detail. However, for everyone's kind of reference, we prepared this table, which kind of lists down in detail the different disclosure obligations, who is responsible to make such disclosures, to which body are we expected to make these disclosures, and most importantly, when. I think when is a very important point to kind of really remember, because it's very important for public companies to always ensure that they are proactive and kind of submitting all the necessary information on time. I think here we've covered like critical information that relates to disclosure and regulatory obligations, but we thought it would be a good idea to kind of move on to discussing other topics that must be considered by the business. Normally, strong business ethics are a cornerstone of corporate governance, particularly for companies looking to go public. Investors, regulators, and the public normally expect companies to have clear standards of ethical behavior, not just on paper, but in practice. There are so many companies out there that have hundreds of different policies, detailed of different procedures and different kind of hierarchy levels. But if there's no actual implementation of those policies, then it's a really counterproductive exercise here. So it's very important to have clear standards on conduct and to kind of have a clear methods into making sure that they are applied, whether that's through oversight or providing the necessary trainings to the different personnel. And I think, especially considering now that the company is a publicly listed entity, it should be noted that maybe before, as a private entity, any such breach could maybe at most lead to a termination. Now, because it may touch upon misleading public, misleading investors, it could lead to more serious kind of offenses and legal consequences. So this is just something to keep in mind. Samer, would you like to touch on quickly on this very important point?
Yes, so I know we don't have much time, but conflict of interest is a very important topic for listed entities. And as we said, things that used to be done under a private entity cannot be done the same way in a public entities. There are several articles that would regulate this under commercial companies law and the corporate governance law into QFMA. So for example, I'm giving you a simple example. If I used to deal with an entity that I own as a chairman, for example, in a private entity, this should have been a straightforward disclosure, or even the company could sign the agreement without any problem. However, when we are in a public entity, this would be considered as a related party transaction. It needs to be disclosed, and depending on the amount of the transaction, whether we go to the General Assembly to get their approval, if the amount of the contract or the transaction is more than 10% of the market value or the nominal value of the company, whichever is lower. So there are a lot very simple examples that we need to really take it into consideration when working when we become a public entity, dealing with third parties and related parties. If as I said, if I used to be, I don't know, working for another entity whereby I used to approve certain contracts, these will not be anymore possible under a public entity. We will need special procedures that need to be followed and disclose that this person has a certain relationship. If I'm a board of director in one company and as well a manager in another company, this could provide a like or raise the point of conflict of interest, and we will need to consider it very carefully in line with the corporate governance code and as well the applicable laws of each place of establishment of the entity.
And I think, I mean, it's kind of like self-explanatory. It's very common for us, like in the Middle Eastern culture, we do have a kind of culture of gifting, you know, but I think once a company goes public, we need to kind of be very vigilant about how we provide those gifts, who do we give them to, and the value needs to be kind of really reasonable for it not to be perceived as a bribe in any kind. And I think particularly when dealing with, let's say, potential parties to a certain bid, then we need to kind of be very careful about the type of gifts or kind of favors that we do for each other there, just to avoid being perceived that there is some kind of suspicious activity happening there. And finally, protection of companies' assets and records. Obviously, this is very important. Again, we touched upon the subject before. Accurate reporting, making sure that all information are factual and that are true and not misleading. Again, public company IP, intellectual property is very important. This kind of protects the company and kind of ensures that it has this continuity of business. So that's very important. Finally, confidential information and the importance of protecting confidential information is very integral here at this stage. And I think this kind of goes.
Yeah.
Sorry, go ahead.
Go ahead, Marwah.
No, I was just going to say, and this kind of goes hand in hand with the next subject that we can discuss, which is the subject of insider trading here.
Yeah, and I would like just to add one. I know that the time of the session completed, but I just want to add something on the confidential information. It's very important when we become public. And then giving you a live example, when I used to be in a private company, I used to sign a contract with X company. The employees used to disclose between each other. Yes, we've been awarded a 50 billion contract, and then suddenly all the people will know. Where in a public company, it cannot be like that. It should be very confidential. People and employees will not be allowed to disclose these information unless they are disclosed in the proper channel. Regulator are aware, proper disclosure is being made. So these things will need to educate our employees in terms of the confidential information, in terms of contracts being signed, awarded, or even in case, for example, there is a decision against the company, seizing the assets of the company. These cannot be in one way disclosed by one of the employees to the media or whatever. So we should follow a really strict rules in terms of confidential information, and this is something as well should be replicated on the employees of the company and how to treat these information that they have in hand.
Again, confidential information, leaking of any confidential information, especially in terms of information that kind of may affect the share price, such as a huge deal or maybe a legal dispute or whatever. It's very critical here because a person who kind of divulges this kind of information, and let's say a third party or a family member decides to sell or buy shares based on that piece of information, this could classify as insider trading, and there are legal consequences to that. So it's very important to kind of make sure that senior management and all levels of employees within the company are kind of trained and they get the necessary learning sessions to really understand their limits as to what to disclose, how to disclose it, and what to avoid to kind of reduce any risk of legal consequences, any ethical consequences, or generally a reputational damage on the company. So we would have loved to kind of go deeper on this subject, but I know that we ran out of time.
Then just an example on the insider trading, as I said, a normal example, if I am the chairman of the company or if I'm the CFO of the company, I have access to the financial information of the company. I cannot buy and sell these shares except if I am following the insider trading rules of the company. So these are something that happen. And then we need to make sure that we act in a really transparent way and in line with the policies that the company has adopted in line public entities rules.
Yeah. And there are certain information for that to kind of happen appropriately. There are certain information that would have to be disclosed with the market as well, and with the QSE, to kind of make sure that people who are part of senior management, who have access to very critical information, can actually trade legally and in a compliant manner, I would say. So I think this is it for today. If anyone has any questions, we'd be happy to take any.
Thank you so much, Samar, Marwah, for that refreshing session. We do have a couple of questions. Let me start. So the first question, is it allowed to sell 10% of shares to any family member?
The answer is yes, to the extent that those family members are not children less than 18 years old and wives.
Clear. Can you please inform us what is the capital requirement for each market?
2 million for venture market, 40 million for main market. Also, we would recommend that having like the 2 million given the versus shares to premium, it will not be workable from a value of shares towards a value of a company. For example, if the company is valued at 40 million, adopting a 2 million share capital is very low, and then this will lead that the price of the share will be 10 or 11 riyal. So normally, even if it's the requirement is 2 million or it's 40 million, we always recommend to have enough capital in order to have the formula between nominal value of the share and share premium has an appetite towards investors. So when you list a share for 2 riyal, 1 riyal premium, 1 riyal nominal value, the impression or the perception of the market or the investor would be much more better than listing a share that for 11 riyal, 1 riyal nominal value and 11 riyal premium. So this is also in international jurisdiction, this shouldn't be a problem, but in the region, it's known that like this formula is adopted. So whereby there should be a close connection between premium and nominal value.
Thank you. And who regulates the process?
Who regulates the process? As we said, it's the single window committee. Now, the approval would come actually officially from the Qatar Financial Market Authority. However, who regulates the process is the single window of capital markets established by the Qatar Financial Market Authority.
Okay. And is it a must to have operations in Qatar?
No, it's not. The company can have operation anywhere. And as we said, company could be established as well anywhere and could list in Qatar. Everything is possible.
Here. Why should the company hire an external law firm for listing? Isn't internal legal staff enough?
No, because the listing rules issued by the Qatar Financial Market request for valuator, listing advisors, lawyers to be appointed for the purpose of running the process. And there are certain undertakings that will need to be signed by the lawyers, by the listing advisors, and as well on the prospectus in relation to this process.
The MLRO officer, must he be an external third-party entity or individual?
It could be both, actually. There are certain companies that they do appoint companies that they act as MLRO. However, we recommend that it should be for sake of confidentiality. We recommend that this person is being adopted and appointed by the company and an employee of the company. He could hold a different role, and this is what listed companies are doing. So the MLRO could hold a financial as well, position, but at the same time acting as an MLRO. So it doesn't need to be only an MLRO doing only MLRO work, but actually it could be an employee that holding two positions in the company, which should reduce the cost.
Clear. I think with that, this is the last question. So again, Samar, Marwa, thank you so much for that session. Thank you everyone for attending and bearing with us. Just a quick reminder, our next session will be on the 27th, and we will be covering financial reporting. Thank you so much. Have a nice
Thank you,
day.
Sulaiman. Thanks,
Thank you
everyone.
so much, Sulaiman. Thank you for the audience. Thank you for granting us this opportunity. And as well, we are happy to ask any to answer any question offline if required. Our details are there. Thank you so much once again to QSE and the audience.
Thank you, everyone.
Thank you.